At 9:08 on a Thursday morning, two tax auditors came to my house and asked why I had hidden $412,000 in construction income. I told them retirement must be paying better than I realized. Neither of them laughed that Thursday morning. The woman closest to the door showed me identification from the State Department of Revenue. Her name was Denise Harper. The second auditor remained beside her. They were field auditors, not police officers, and they made it clear that no final tax determination had been issued. They were there because notices sent to the business address had gone unanswered, while a later records match connected the reported majority owner to my home. "Mr. Pierce," Denise said, "are you the majority owner of Pierce Civic Builders Limited Liability Company?" "No." She looked down at the folder in her hands. "The confidential tax ownership schedule lists you as holding 80%. "I have never heard of it." The auditors exchanged the kind of glance professionals use when an interview stops following the prepared sequence. "May we come inside?" Denise asked. I led them to the dining table. The second auditor remained standing until I sat. Denise explained that I could contact counsel before answering detailed questions. I told her I would not speculate about a company I did not recognize, but I wanted to see the documents that carried my name. She turned the folder toward me. There was my full legal name, my date of birth, my social security number, partly masked on the copy, my old contractor's license number, and beneath them was a signature that looked enough like mine to fool someone who had never watched me write. The final stroke leaned too far left. I had broken my wrist at 47 and changed the way I finished the letter E. Whoever copied that signature had taken it from something older. "This is not mine," I said. "You are saying you did not sign the formation documents?" "I did not form the company, authorize anyone to form it for me, or agree to own any part of it." The second auditor wrote each answer. Attached to the filing was a photograph of me in a yellow hard hat at the East Marlow Library project 19 years earlier. I stood beside a concrete wall with a rolled plan under one arm. The picture had once hung in the office of my old company. The Pierce Civic Builders website described me as founder, majority owner, and senior construction advisor. It said I had returned from retirement to teach the next generation of Pierce builders. That next generation was my son, Evan. His photograph appeared beneath mine with the title Director of Operations. His wife, Mallory, was listed as Finance and Compliance Manager. The auditors showed me a business tax schedule. Pierce Civic Builders had reported pass-through income allocated to me, even though no corresponding personal return had been filed. Some payroll and sales-related taxes were also under review. Denise repeated that the figures had not yet become a final debt against me. "The audit is intended to determine who owned the company, who received the income, and whether the filings are accurate," she said. "Did the money go?" "That is one of the questions." Denise explained that the tax mismatch had triggered a cross-agency referral because the same ownership identity appeared in licensing, municipal procurement, and supplier credit systems. Her folder contained only the tax ownership schedules, formation records, and identity verification documents released for my audit notice. The licensing board, city, and suppliers held their own underlying records. "We are not asking you to answer for documents you have not seen," she said. "We are asking whether the ownership reported for tax purposes is genuine." She asked whether I had received income, distributions, salary, or benefits from Pierce Civic Builders. "No." "Did you allow Evan or Mallory to use your contractor's license?" "No." "The license has been inactive since I retired. Did you permit them to use your project history?" "No." The second auditor asked when I had last worked in construction. 3 years ago. I closed Pierce Contracting after my wife died. I sold the equipment, completed every warranty obligation, and notified the licensing board that I was retiring. "Did your son assume that company?" "No." "Evan had his own business." Crestline renovation. I stopped there. Crestline was not a subject I discussed casually, even with auditors at my table. Denai slid a written notice toward me. It opened an examination of the reported income and company ownership. It gave me time to respond, provide an identity theft affidavit if appropriate, and appoint a representative. Collection on the disputed income would not begin while ownership and identity were under review, provided I responded by the deadline. Do not sign anything today merely because it appears to correct the company record, she said. Speak with counsel. Can you give me copies of everything in this audit packet bearing my name? She could provide the documents attached to my notice and a list of the filings at issue. Other records would require a formal request through the audit process. I want the copies. While the second auditor prepared them, I looked again at the photograph from East Marlow Library. Donna had taken that picture. We opened Pierce Contracting in a rented office above a plumbing supplier when I was 30. I estimated jobs and supervised sites. Donna managed payroll, taxes, insurance certificates, and every number I was tempted to call close enough, she never allowed close enough into the books. A building can hide a bad beam for years, she once told me. A set of books cannot hide a bad number forever. On the day we moved into our first proper office, she gave me a brass nameplate, Samuel Pierce. Belder. The letters were simple and heavy. I kept the plaque on my desk through 35 years of permits, inspections, weather delays, arguments, and final walkthroughs. On the back, Donna had written a sentence with an engraving pen. Your name goes on every wall you build. Make sure it can stand. That sentence became the rule neither of us needed to post. We did not submit a low bid and recover the difference through invented change orders. We did not move safety costs into another column because a deadline was uncomfortable. If a supplier was owed money, Donna scheduled payment before we paid ourselves. We had difficult jobs. We had delays, damaged materials, and one foundation we removed at our own cost because the test results were wrong. What we never had was a fraud judgment, an abandoned project, an unpaid supplier lien, or a safety suspension. Pierce Contracting employed no more than 28 people, small enough that I knew which foreman needed written instructions, which supplier would answer before sunrise, and which inspector would stop a rush job without apologizing. That familiarity was not favoritism. It was accountability. When my name appeared on a proposal, everyone involved knew exactly who would answer if the work failed inspection. Even grew up around that reputation. As a boy, he swept the shop for spending money. At 16, he asked why clients shook my hand before reading every page of a proposal. Because they have read the pages that came before this one, I told him. I thought he understood. When he started his own renovation business, I offered advice but refused to lend him my license. Evan called that a lack of faith. I called it the difference between teaching someone a trade and letting him sign your name. Donna usually softened the argument. After she died, there was no one left who could translate my caution into something Evan did not hear as judgment. When I closed Pierce Contracting, Evan and Mallory helped scan tax archives, equipment sale documents, warranty records, licensing files, and project photographs. I gave them access because Donna had handled the books, and I trusted family to help organize what remained. That was how they obtained my driver's license scan, social security information, old and recent signatures, and the history of the company. Trust gave them access. It did not give them authority to build another business with it. When I closed the company after her death, I brought the plaque home and placed it on a shelf in my study. The Pierce Civic Builders website used a photograph of the front. Evan had been inside my study many times. He had taken the image without mentioning it. He had photographed the letters his mother gave me and attached them to a company I did not know existed. He had never bothered to show the back. The auditors left at 10:36. I stood in the doorway until their car reached the end of the street. Then I carried the copied file to my study and set it beneath the brass plaque. I did not call Evan immediately. I read every page first. Civic SIG builders had been formed 14 months earlier. The operating address was the post office box. In the confidential tax schedule and operating agreement, I was listed as 80% owner, Evan as 15%, and Mallory as 5%. The licensing packet named me responsible managing member and qualifying party. My supposed capital contribution was listed as $150,000 in equipment, license value, and business goodwill. I had contributed nothing. My equipment had been sold before the company existed. The filing claimed I had authorized Evan to conduct daily operations while retaining final approval over contracts and debt. That arrangement ensured he controlled the work, while my name carried responsibility. The signature on the operating consent looked newer than the one on the formation document. Someone had copied from more than one source. I found another attachment showing previous public projects: East Marlow Library, the West County Fire Station, a school gymnasium, 2 drainage improvements. Every project belonged to Pierce Contracting, not Pierce Civic Builders. Several employees listed as current supervisors had retired or moved away years earlier. One had died before Pierce Civic Builders was formed. My safety record appeared without the name of the company that earned it. The application made Evan's new business look like a continuation of mine while directing every legal obligation back to me. The formation signature matched an old warehouse contract. The later consent resembled my equipment sale agreement. Someone had selected signatures from different periods to survive separate checks. At 11:48, I called him. "Dad," Evan said. "Everything okay?" 2 state tax auditors came to my house. The silence lasted less than a second. "This is about Pierce Civic, isn't it?" I had not said the company name. "You tell me." "Mallory has been trying to straighten out a filing issue. It is clerical. Nothing for you to worry about." "Why is my name on it?" "Because we used some family history for qualification. It was supposed to be temporary. The records say I own 80%. That is part of the filing problem. The ownership percentages were structured for bonding and tax purposes. We were going to amend them." "Who signed my name?" He did not answer. I waited. "Dad, don't talk to anyone else until Mallory and I come over. If the state misunderstands this, they could freeze the company. We have employees. We have projects. The state already came to me. Let us explain before you make this bigger." He said us as though the mistake belonged to the family, and the solution required my cooperation. "Bring whatever explains it," I said. Tonight. After the call, I searched the public business registry. Pierce Civic Builders existed. My name appeared only as managing member and controlling principal beside the post office box. The public page did not display ownership percentages, social security information, guarantees, or the documents behind the filing. The licensing portal showed that Pierce Civic held a company qualification associated with my inactive contractor record. The public page did not reveal the supporting packet. The audit index said the private licensing file contained a forged reactivation and association request, a qualifying party consent, and a statement that I had returned from retirement as responsible manager. A false email account in my name had answered the board's follow-up questions. Pierce Civic's company qualification rested on the claim that I supervised its work, my documented experience. My credit report showed 3 business guarantee inquiries from a materials distributor, equipment lender, and fuel provider. Separate alerts had looked administrative because no personal account appeared. Together, they outlined a company using my credit while sending correspondence elsewhere. I froze my personal credit before opening the company website. The freeze would not undo existing guarantees, but it could prevent anyone from using my identity for another account while I sought legal advice. Then I searched the company website. The brass plaque appeared at the top of the About Us page. Beneath it, a sentence said our founder had returned to guide a trusted family company into a new generation of public construction. The project gallery mixed current photographs with work completed by Pierce Contracting years earlier. Captions removed dates and described each project as part of our continuing public service portfolio. A safety page quoted procedures Donna had written for my old employee handbook. Even the language beneath my photograph came from a retirement speech Evan had attended. They had not borrowed a logo. They had assembled a living version of me from documents, photographs, and sentences I once trusted my family to possess. My son had not opened a company in the family name. He had opened one inside mine. The tax auditors had come looking for income I had hidden. What they found was a company my son had hidden inside my identity. Evan and Mallory arrived at 7 that evening carrying 2 laptop bags and a folder marked corrections. Mallory walked into the dining room as though she had come to prepare quarterly taxes. Evan remained by the door until I told him to sit. Neither asked what the auditors had shown me. Mallory opened the folder. "The state is treating an internal ownership structure as taxable income," she said. "We can correct it before anyone turns this into something it isn't." The first document was a backdated operating agreement. It said I had agreed 14 months earlier to own 80% of Pierce Civic Builders while delegating daily management to Evan and financial administration to Mallory. The second was an owner consent approving tax treatment and company debt. The third confirmed that the contractor history attached to city bids belonged to a continuing Pierce family enterprise. The fourth acknowledged my personal guarantees to suppliers. "You want me to sign these now?" I asked. "They memorialize what everyone understood," Mallory said. "I did not understand that the company existed." Evan leaned forward. "Dad, this started as a temporary qualification structure. We needed your experience in the ownership package. Once the company established its own record, we planned to transfer the shares. Who signed my name?" He glanced at Mallory. Some documents were submitted electronically. The filing service used signature authorizations from the package. "Which authorization did I sign?" Neither answered. Mallory moved the backdated agreement closer to me. "The tax issue exists because the ownership paperwork is incomplete. If you sign the corrections, we can amend the filings and show that Evan operated the company under family authorization. That would make the old signatures authorized. It would clarify intent." Intent was the word she chose when consent would have exposed the problem. I turned to Evan. "Why couldn't you qualify under your own name?" "We could. It would have taken longer. That is not what I asked." He rubbed one hand across his jaw. Crestline had a difficult year. I knew about the school renovation that finished late. I did not know the full cost of it. Evan's first company, Crestline Renovation, had won a contract to modernize part of a middle school. He underbid the work, expecting change orders to cover conditions he claimed the plans did not show. The city rejected several requests. Suppliers tightened terms. Schedules slipped. Then a safety inspection found an unprotected opening and inadequate fall controls. Work stopped for 3 days. The delay triggered damages under the contract. Evan had told me the city used him as a scapegoat for bad design. Mallory's papers revealed more. Supplier lines, disputed customer deposits, a suspended license. A bonding company that refused further coverage. An internal city watch notice requiring additional review of any company controlled by Evan Pierce. Crestline's collapse had not happened in 1 week. 6 months before the school deadline, Evan asked me to call a concrete supplier who had moved him to cash terms. I refused to guarantee the account, but offered to sit with him and rebuild the schedule. He wanted the phone call, not the schedule. Later, he asked whether Pierce Contracting's old bond history could be referenced as family experience. I told him his company could describe work he personally performed while employed by me, But it could not claim projects, bonding capacity, or safety records it had not earned. He called that a technical distinction. When the school project failed, I paid none of Crestline's debts. That decision cost us nearly a year of regular conversation. Evan believed a father with clean credit should use it to keep his son's company alive. I believed rescuing the company without changing its practices would only finance the next failure. Pierce Civic Builders was his answer. Instead of repairing the record attached to his name, he had built a new company around mine. Crestline did not have a difficult year, I said. It failed. Evan's chair moved against the floor. It failed because no one gives a small contractor room to recover. You had 30 years to build relationships. I made one mistake and every supplier treated me like a criminal. One mistake did not create 4 liens and a safety suspension. You always had the city on your side. The city inspected my work too, and when your name was on a bid, people assumed you would finish. There it was. He did not believe my reputation came from 35 years of decisions. He believed it was an advantage the industry had handed me, and then unfairly denied him. So you put my name on your next company. I wasn't stealing your name, Dad. I was keeping the Pierce name alive. I looked toward the study where Donna's plaque sat beneath the copied tax file. You kept the letters. You threw away everything they meant. Mallory closed the folder halfway. This is not about philosophy. The company has active projects and 17 employees. If the audit spreads to licensing and procurement, suppliers will freeze us. Workers will lose jobs. Who owns the company? Operationally, Evan and I do. On paper, you do. Who receives the money? The company. Who receives distributions? She hesitated. We have not made formal distributions. Cash remains tied to operations. The tax schedule said profit had passed through to me. Mallory said no cash reached me. Both could not be treated as harmless bookkeeping. Even lowered his voice. Dad, just sign the corrections. Once the next city contract comes through, we can pay everything back. What contract? Mallory answered. The Riverside Community Center. $6.4 million. Pierce Civic is the proposed awardee, pending final compliance approval. They wanted me to adopt 14 months of false documents so the company could pass one more review under my name. I gathered the papers into the folder and returned it. I will not sign anything tonight. Evan's face changed. Then what are we supposed to tell the state? Tell them the truth. Mallory stood. Your name is an asset. Families use assets. Assets have owners. Mallory looked at Evan before answering. If anything went wrong during qualification, the city would see a retired contractor with a clean record, not another extension of Crestline. The 80% structure gave reviewers confidence. It was never meant to hurt you. It was meant to make them believe I controlled a company I had never entered. It was meant to get us through the door. Her explanation was not an apology. It was the design. She placed the folder in her bag. We will give you time to calm down. After they left, I photographed every page they had placed on my table and wrote down the conversation while I could still separate their exact words from what I wished I had said. The following morning, I met Rachel Kim. Rachel was a construction and business fraud attorney with an office 2 blocks from the licensing board. I had obtained her name from the lawyer who handled the sale of my equipment. She listened while I described the audit, confidential ownership schedule, public registry, and documents Evan wanted me to sign. Then she examined the photographs. Do not sign any version of these, she said. A backdated agreement would not merely correct a clerical error. It could be used to argue that you adopted prior acts and accepted obligations. Can I be held responsible because the filings name me? The filings create problems. They do not make the fraud true. We respond institution by institution with evidence that you did not consent, receive funds, or control the company. That day, Rachel helped me sign an identity theft affidavit and a statement disputing ownership. We submitted both to the tax auditors with a request to suspend collection activity while the reported income and beneficial ownership were examined. The Department of Revenue acknowledged the dispute in writing. The reported $412,000 remained under examination rather than becoming an immediate collectible debt. I still had to cooperate, identify legitimate retirement income, and respond by each deadline. An identity theft affidavit opened an investigation. It did not erase a tax schedule by magic. Rachel disputed the formation and managing member filings, alerted the licensing board, and preserved the post office box and filing service records. Credit bureaus added extended fraud alerts beside my freeze. Lenders identified through my credit report were told that I disputed every guarantee and that applications, calls, and approval records had to be preserved. The licensing board placed the Responsible Manager Association under review and prohibited further reliance on my record until the dispute was resolved. It did not instantly revoke Pierce Civic status. The board needed the application history and an opportunity for the company to respond. She also told me what we could not do. I could not access company accounts merely because the filings falsely called me owner. I could not direct employees, seize computers, or pretend Rachel represented Pierce Civic. Maya Chen, the forensic accountant Rachel intended to hire, could review public records, tax documents released to me, records obtained through lawful requests, and anything Evan or Mallory voluntarily provided. They put you on paper as the owner, Rachel said. That was fraud. But it also means every institution they contacted has a record tied directly to your name. They want me to help correct those records. Then let them explain what they want corrected. Do not promise to approve it. Do not lie about what the government is doing. You may truthfully say you will review every document carrying your name. Maya joined us that afternoon. She began with the tax schedule, operating agreement, and formation records. They reported profit under your name and moved the cash under theirs, she said. To establish the path, I need the general ledger, bank statements, contracts, invoices, delivery tickets, change orders, payroll records, and related company payments. We do not have those. Your son may give them to you if he believes they are necessary for your signature. Rachel looked at me. Ask for records, not confessions. That evening I called Evan. I have considered what you said. He did not speak at first. Are you going to help? I will review the corrections. But I will not sign any page without the records behind it. What records? Every document carrying my name. Formation papers, tax schedules, credit applications, guarantees, bid packages, city contracts, invoices, change orders, supplier statements, accounting files. If you want me to accept responsibility, I need to know what responsibility means. That is a lot of material. You used my name a lot of times. He covered the telephone and spoke to Mallory. I heard only fragments. Then he returned. We can put together a secure folder. You need to understand some records are internal. My signature is not internal. Will you come to the Riverside compliance hearing if we resolve this? The city expects the founder to appear. I will consider it after I review the file. The next morning, Mallory sent a selected folder of corporate records, tax work papers, bid packages, and invoices. Rachel's office preserved the delivery exactly as received before Maya opened anything. The first upload looked extensive but omitted the general ledger, bank statements, and native accounting file. Maya made a list of what the folder referenced but did not contain. Invoice numbers skipped. Change orders pointed to missing approvals. Tax work papers cited a profit and loss report that had not been included. A supplier balance referred to 3 guarantees, while the folder contained only 1. I sent Evan the list without accusation. Maya says these records are necessary before I can understand the corrections. Who is Maya? An accountant reviewing the tax issue. You hired a forensic accountant. You reported $412,000 under my name. A bookkeeper would not be enough. He was silent, long enough for me to hear a door close on his end. Dad, these files contain confidential payroll and banking information. Then remove employee social security numbers and provide the business records. I will not accept 80% of a company while being allowed to see 20% of its books. Mallory called an hour later. She tried to limit the review to documents the auditors had already mentioned. I told her the backdated owner consent covered all company contracts and debt. If she wanted that signature, the scope of my review would match the scope of the responsibility. By evening, a second upload arrived. It contained a curated accounting export, PDF bank summaries, selected change orders, invoice support, subcontractor payments, and emails chosen by Mallory. She believed the entries could be defended as reimbursements, management payments, or ordinary job costs. Rachel preserved that delivery too. Native bank records, complete delivery histories, invoice metadata, and unedited email threads were still missing. Maya would use the internal folder to identify gaps, then compare them with lawful city records, supplier certifications, rental meters, bank confirmations, inspection logs, and licensing files. We would never enter a company system ourselves. Nothing in the folder called itself fraud. A transfer was labeled management reimbursement. A missing delivery ticket looked like poor filing. A payment to Mallory's subcontractor carried an ordinary invoice. The evidence would depend on whether independent records confirmed the explanations they had selected. Mallory believed those labels made the selected exports safe to share. The folder did not prove every suspicion. It did something more useful. It fixed Evan and Mallory's version of the company in records they had chosen to send while asking me to adopt it. They could no longer claim later that I had misunderstood a single tax notice. Evan believed I had agreed to save his company. What I had agreed to do was read every page he had been hiding behind my name. Maya did not begin with the largest invoice. She began with the $412,000 the company had reported under my name. The tax work papers treated Pierce Civic Builders as a pass-through business. 80% of its reported taxable income had been allocated to me because the filings called me the majority owner. That allocation did not prove I received cash. It created a tax question that had to be reconciled with the company's bank records. Mallory's selected export identified transfers described as owner distributions, but did not include complete native bank data. Maya treated the entries as leads, not proof. Bank confirmations obtained through the tax and municipal reviews later supplied dates, recipients, and account ownership. None went to me. The company's primary operating account sent money to two accounts controlled by Evan and Mallory, paid personal expenses on their behalf, and transferred funds to creditors connected to Crestline renovation. Some entries were coded as reimbursements, others were management advances or subcontractor payments. They reported profit under your name and moved the cash under theirs, Maya said. The accounting file contained an equity account labeled Samuel Pierce Capital. It showed the $150,000 I supposedly contributed through equipment, license value, and goodwill. The entry had no deposit behind it. No equipment title transferred. No appraisal supported the number. It was a journal entry designed to make the ownership structure look funded. Maya prepared a schedule distinguishing three things the tax filing had blended together: income reported to me, cash retained by the company, and money that ultimately benefited Evan or Mallory. She also searched for evidence that I had ever acted like an owner. There was no payroll payment to me, no deposit into my accounts, no expense reimbursement, no login from my devices, no meeting minute I attended, and no email sent from an address I controlled. The supposed owner approvals came from the false account created in my name. The business paid insurance and license fees associated with my identity. but those payments benefited the company using it. They did not prove I knew the company existed. Maya compared each confirmed transfer with my accounts. None connected me to company cash. Rachel sent the schedule to Denise Harper with the selected records Evan had voluntarily provided and requested independent bank verification through the audit. Collection against me stayed suspended while beneficial ownership and identity theft were reviewed. Do not expect the tax record to be corrected in a week, Rachel warned. We are proving that the legal owner on paper was not the real owner in practice. Every account, signature, and transfer has to support that. The supplier files created a second trail. The supplier's credit manager had approved Pierce Civic Builders for a $200,000 line, based partly on my guarantee and prior payment history. Rachel contacted her through the preservation notice. The supplier later produced certified application and delivery records through council and the government reviews. The credit package included a scanned driver's license, the same old signature used on the formation document, and a financial statement assembled from public property values and estimates of my retirement assets. It also contained a recorded verification call. The woman on the call identified herself as Samuel Pierce's financial assistant and said I had authorized Mallory to complete the account. The supplier had other recorded calls in which Mallory used her real name. The callback number, account metadata, and voice matched those authenticated recordings. Counsel confirmed the comparison without requiring a complex forensic audio claim. The supplier's records also showed where materials were delivered. Most went to active Pierce Civic sites. The guarantee was false, but the delivered materials were real obligations of the company. One set of deliveries, however, did not match the city's invoices. Pierce Civic had a $1.7 million contract for stormwater improvements along North Valley Road. The company billed the city for drainage pipe, concrete barriers, aggregate, emergency labor, and several change orders after heavy rain. The city invoice folder claimed 84 sections of drainage pipe had been installed. The supplier delivery records listed 46. Maya checked whether another supplier had provided the difference. No second vendor appeared in the accounting file. She checked equipment logs, subcontractor bills, and inventory adjustments. Nothing accounted for 38 additional sections. Could the delivery tickets be missing? I asked. Yes, that is why we do not accuse anyone from one set of books. The city and supplier have their own records. Rachel contacted Lena Ortiz, the city's procurement director, and disclosed the disputed ownership, license history, and contractor qualifications. She did not send private tax material the city had no right to receive. She provided my identity theft statement, public formation record, and the bid pages using my project history. Lena responded within a day. Pierce Civic Builders was already the proposed awardee for the $6.4 million Riverside Community Center, but the recommendation remained subject to final compliance approval and council authorization. No contract had been executed. The company had qualified using public project experience, safety history, and personnel records attributed to me and Pierce Contracting. The company did not qualify on Evan Pierce's record, Lena said during a meeting with Rachel and me. It qualified on a record Samuel Pierce never authorized it to use. The bid package treated East Marlow Library, the fire station, school gymnasium, and drainage projects as Pierce Civic experience. It listed former Pierce Contracting supervisors as available personnel without current agreements. It used my old safety record and bond history while omitting Crestline's suspended license and supplier liens. Lena showed me the scoring sheet. My project history supplied enough experience points to move Pierce Civic above two competing bidders. My name had not merely decorated a website. It had changed the procurement result. The licensing board found the same design. Pierce Civic attached my inactive license, a forged responsible manager consent, and old project photographs. When the board requested clarification, Mallory replied from the false email in my name and said I remained actively involved. The bonding application described Crestline as a separate failed venture and Pierce Civic as a new company controlled by an experienced majority owner. Limited coverage had been issued only after the surety received my supposed guarantee and financial statement. She opened an internal procurement review and suspended final compliance approval without announcing a final disqualification. City Council wanted the underlying records preserved and the existing North Valley invoices audited before staff made a public recommendation. I asked what would happen to the workers. Lena said the city held retainage and could separate verified payroll, supplier and subcontractor claims from disputed billing. Riverside had not started. Active work could be transferred to another contractor. I could not guarantee no job would be lost, but concealing the fraud through one more contract would attach more workers and suppliers to the eventual collapse. Owen Brooks led that audit. He had reviewed public works billing for 14 years and had no connection to my old company. Maya provided an index of discrepancies found in the files Evan sent. Owen obtained the city's original invoices, inspection logs, field photographs, payment approvals, and change orders through municipal systems. The supplier provided certified delivery records. Through the city's audit request, the numbers did not reconcile. Mallory's export had only exposed missing ticket numbers and unexplained entries. The independent records completed the evidence: certified supplier deliveries, city inspection logs, rental meter reports, authenticated change orders, and bank confirmations. No single internal spreadsheet served as a confession. The contradictions appeared only when their selected story was measured against records they did not control. The city paid for 84 drainage sections. The supplier delivered 46. The billed concrete barriers exceeded the number visible in inspection photographs and daily reports. Labor invoices charged crews for days when weather logs showed the site closed. 2 change orders carried my electronic approval, even though I had never accessed the city's vendor portal. 1 change order claimed an emergency redesign after an underground conflict. The city engineer listed as approving it had been on medical leave that week. The digital file contained a pasted approval image, not the engineer's authenticated portal signature. Owen compared the contractor's daily reports with the inspector's logs. Pierce Civic reported 12 workers on a Saturday when the inspector recorded 4. Equipment hours exceeded the rental company's meter records. An invoice for traffic control covered a road closure that the city had never approved. This is not a single bad quantity, Owen said. The source records were changed to support the billing. Maya followed the payments after the city released them. Money from North Valley moved into the operating account, then left through transfers that did not follow the project's costs. 1 payment went to settle an old Crestline supplier balance. Another covered a personal loan in Evan's name. Company funds paid installments on Mallory's luxury vehicle and rent on a vacation apartment the couple used several weekends a year. The largest questionable transfer went to a subcontractor formed 6 months after Pierce Civic. Mallory owned the subcontractor through a separate limited liability company. It billed for administrative coordination and emergency procurement, but had no employees, equipment, or supplier purchases matching the work. From that account, money moved into Evan and Mallory's household account. Maya did not call every transfer theft. Owners can receive compensation, and companies can repay legitimate expenses. The problem was that the same money had been billed to the city as pipe, barriers, labor, and emergency work that records did not support. The municipal invoice says the money bought a drainage section, she said. The bank transfer says it paid a Crestline creditor. Both cannot describe the same dollar honestly. The documents Evan wanted me to sign became a third trail. The backdated operating agreement would make me the majority owner from formation. The owner consent would adopt company debt. The tax amendments would say I permitted Evan and Mallory to manage the business. The guarantee acknowledgement would validate supplier credit after the fact. The qualification confirmation would declare that Pierce Civic had permission to use my old projects. Rachel placed them in chronological order. These were not corrections, she said. They were requests for Mr. Pierce to retroactively adopt fraud already committed in his name. Evan continued sending messages asking whether I had finished my review. I answered truthfully. The records were still being examined. I had not agreed to sign. He heard only the possibility he needed. Mallory called the next evening with a different approach. "The tax amendments are ready," she said. "We removed language that made you uncomfortable. Do they still say I knew about the company? They say you authorized family management. I did not. If you attend Riverside as founder and then deny ownership, you will look inconsistent. Then remove me from the program." She became quiet. "Evan needs you there. The council has questions about continuity. You can make this survivable. If the company loses Riverside, 17 people pay for a family disagreement." This stopped being a family disagreement when my signature reached the city. I ended the call without revealing what Lena and Owen had found. Rachel had instructed me not to discuss the scope of the municipal audit while preservation requests were being completed. 3 days before the Riverside hearing, he came to my house with a printed agenda. The event was described as a public procurement compliance hearing concerning the proposed award, pending final approval and council authorization. My photograph appeared beside the title founder and senior advisor. "They want continuity," Evan said. "After all the questions, seeing you there will settle people down." "Who wants me there?" "The city wants the ownership team available. Suppliers will be there. Local press too. What do you want me to say?" He handed me a page drafted by Mallory. It said I had returned from retirement to guide Pierce Civic, trusted Evan with daily operations, and remained proud of the company's standards. "You expect me to read this?" "Use your own words. Just confirm the family story. And the corrections, bring them. We can sign after the hearing with council. Once Riverside is secure, the cash flow fixes the old issues." He still believed the next contract could repair the last one before anyone looked closely enough. "I will attend," I said. Relief crossed his face. "I knew you wouldn't let this destroy us." After he left, I called Rachel. City Council had already decided that the Riverside recommendation could not proceed without addressing the identity and audit findings on the public agenda. The hearing remained scheduled because it was the formal point at which Pierce Civic could present its qualifications, and staff would report whether compliance approval had been granted or suspended. No one had promised Evan an executed contract. He had promised himself. Lena would not stage a false celebration or permit a vote on a recommendation she no longer supported. Evan had received notice that final compliance remained pending. He interpreted pending as a delay my appearance would cure. Maya completed her summary. Rachel prepared the identity and ownership record. Owen assembled the certified city audit exhibits. Lena prepared the procurement determination. I took Donna's brass plaque from the study shelf and cleaned the dust from the letters. On the front was the name Evan had copied. On the back was the part he had ignored. "Your name goes on every wall you build. Make sure it can stand for 35 years. I treated that sentence as a promise to clients and workers. At City Hall, it would become the boundary between the company I built and the one Evan placed inside its shadow. Evan wanted me on stage because the city still trusted my face. He did not know the city auditor would be standing 2 seats behind me. City Hall convened a public procurement compliance hearing concerning the proposed Riverside Award. Pierce Civic Builders placed qualification boards along one wall. Employees, suppliers, council members, competing contractors, and local reporters filled the seats. A screen displayed the words proposed awardee pending final compliance approval. Even seemed to notice only proposed contractor. Mallory stood beside the bid binders as if neat paperwork made every claim true. I arrived with Rachel. Donna's brass plaque was wrapped in a dark cloth beneath my arm. Lena Ortiz met us near the front. "The company will present its qualifications," she said. "Then procurement staff will report the compliance findings. Tax matters and non-public bank records will not be discussed beyond what you authorized regarding identity." Owen sat 2 seats behind the place reserved for me. A certified binder of municipal invoices and field records rested in front of him, even crossed the room when he saw me. "I knew you would come." He reached toward the wrapped plaque, then stopped. "Is that from the old office?" "Yes, perfect. We can put it on the display table after you speak." Mallory joined us. "Did you bring the amendments?" "Rachel has every document you asked me to review." Mallory looked at Rachel, and some of her confidence left. This was supposed to be a family correction. "My signature stopped being a family matter when it appeared on public contracts," I said. Lena called the meeting to order before Mallory could answer. She explained that Pierce Civic remained the proposed awardee from the initial scoring process, but no award would become effective without final compliance approval and council authorization. The hearing allowed the company to present its qualifications before staff issued its recommendation. Evan walked to the lectern. He spoke well. That had never been his problem. He described local hiring, efficient scheduling, and a family tradition of public construction. Slides showed East Marlow Library, the West County Fire Station, and drainage projects completed years before Pierce Civic existed. "This company carries forward the standards my father established," he said. Samuel Pierce returned from retirement because he believed the next generation was ready to build on what he began. Then he invited me to join him. I carried the wrapped plaque to the lectern and placed it where the council could see. When I removed the cloth, the brass letters caught the overhead light, Samuel Pierce. "Builder?" Evan smiled for the cameras. "My mother gave him that plaque when our family company opened," he said. "Your mother did," I replied. I turned the plaque over so the inscription faced the council. "Your name goes on every wall you build. Make sure it can stand." The room became quiet. "Evan is right about one thing," I said. "Pierce Civic Builders has been carrying my name. The problem is, it never had my permission." His smile disappeared. I stated my name for the public record and explained that I had retired 3 years earlier, never formed Pierce Civic, never owned or managed it, never authorized my license or project history, and never guaranteed its credit. "The state filings list you as majority owner," a council member said. "Those filings are disputed through a signed identity theft affidavit. I received no company income, controlled no account, and signed no formation or ownership document." Rachel submitted the affidavit. Signature comparison, retirement notice, and correspondence confirming that the tax and licensing reviews were open. She did not claim those investigations had reached final judgments. Mr. Pierce was asked to sign a backdated operating agreement, owner consent, amended tax forms, qualification confirmation, and guarantee acknowledgement, she said. These were not corrections. They were requests for him to adopt fraud retroactively. He signed none of them. Evan moved toward the second microphone. "Dad, you said you would help me fix it." "I said I would review everything carrying my name." "I did," Mallory asked to respond. Lena reminded her that the company would receive a formal opportunity through the compliance process, but allowed a brief statement because ownership had been part of Pierce Civic's presentation. "We built this company," Mallory said. "Samuel's history was contributed as a family asset. He knew Evan was continuing the Pierce businesses. Then you should have been willing to put your own names on it," I said. Lena took the lectern. She displayed the qualification score without revealing confidential competitor information. Pierce Civic had received credit for public projects completed by Pierce Contracting. Personnel no longer employed by the family, my safety history, and bond experience linked to my record. The company did not qualify on Evan Pierce's record, she said. It qualified on a record Samuel Pierce never authorized it to use. She explained that Crestline's license subscription, supplier liens, and bonding restrictions had not been disclosed as part of the controlling management history. The false majority owner structure had allowed reviewers to treat Pierce Civic as a new firm led by a contractor with a clean record. Pending compliance is not approval, Lena said. Staff cannot recommend execution of the Riverside contract on this record. Owen spoke next about North Valley. He limited his presentation to municipal records cleared for the public audit summary. The city paid for 84 drainage sections. Supplier certifications documented 46 deliveries. Field photographs and daily logs did not account for the difference. Labor hours exceeded inspector records. Equipment billing exceeded meter reports. 2 change orders relied on approvals that were not authenticated through the city's system. The city paid for 84 drainage sections, Owen said. The supplier delivered 46. Evan shook his head. There were secondary deliveries. The job superintendent has tickets. Those tickets were requested during the audit, Owen said. The company did not produce them. Owen then summarized the forensic schedule Maya had submitted through the audit. Without displaying private accounts, he stated that pass-through profit had been allocated to my tax identity while no payment reached me. Confirmed transfers moved city funds to Crestline creditors, personal obligations, and a subcontractor owned by Mallory. Those were legitimate reimbursements, Mallory said. The invoices described pipe, barriers, labor, and emergency procurement, Owen replied. Not management reimbursements. A council member asked Evan, who controlled the operating account. Mallory handled daily finance, he said. I approved major payments. Did Samuel Pierce approve payments? Not individually. I had operational authority. From whom? Evan looked toward Rachel's binder. The company documents delegated it. The documents carrying a signature he disputes. Evan did not answer. Mallory tried to separate the forged ownership from the invoices. Whatever happened during formation, the work was real. Samuel's name helped with qualification, but Evan ran the projects. The statement confirmed both parts of the problem. I had not controlled operations, yet my identity had been presented as the reason the company deserved public trust. Lena asked why 80% of the company had been placed in my name if Evan and Mallory owned and operated it in practice. The structure reflected contributed reputation and experience, Mallory said. Did Mr. Pierce agree to contribute either? We believed family history belonged to the family. That is not an ownership consent. Lena summarized the certified supplier credit exhibit without revealing private pricing. Credit had been extended because I appeared to be the guarantor and majority owner. The verification call came from Mallory's callback number, and the voice matched authenticated supplier recordings in which she used her real name. I never participated. Mallory said she had authority through the operating agreement. Rachel held up the unsigned backdated version. Mallory wanted me to adopt. This agreement was sent after the tax audit began, Rachel said. It cannot authorize a call made the previous year. Evan looked at me instead of the council. You don't understand what was at stake. If Riverside disappears, the company is finished. I did understand. I understood the employees behind him, the suppliers who had extended real materials, and the projects the city still had to complete. Your company could not survive an inspection, so you borrowed a name that could. I was trying to keep the Pierce name alive. You kept the letters. You threw away everything they meant. Mallory gripped the edge of the table. This will destroy us. No, the invoices did that. I only stopped standing between them and the truth. Lena announced the immediate procurement actions. The Riverside recommendation was suspended and removed from the award calendar. Pierce Civic's bidder eligibility was placed on temporary hold. Existing city contracts would undergo expanded audit. The qualification and billing records would be referred for procurement fraud, licensing, tax, and surety review. The city would preserve retainage and separate verified worker, supplier, and legitimate subcontractor claims from disputed management charges. Riverside would move to the next lawful procurement step. Rather than begin under a contractor that had failed compliance, no one was arrested. 2 investigators waiting outside the chamber served preservation demands and subpoenas for company devices and records. Evan and Mallory were instructed not to delete, transfer, or destroy data. The notices did not declare them guilty. They ensured the evidence would remain available to the agencies responsible for deciding that later. Evan had walked into City Hall expecting my name to win him another contract. He left knowing it had become the first line of the audit that would close his company. The consequences took months. The Department of Revenue completed its ownership review and removed the false pass-through income from my personal liability. Legitimate retirement income remained mine to report as usual. The supplier guarantees were disputed individually. Those unsupported by any real consent were rescinded or reassigned through settlements. While suppliers pursued Pierce Civic and the people who had actually controlled it, clearing my name was not one order delivered to every institution. Rachel and I answered each account separately. We supplied signature comparisons, the identity theft affidavit, proof of retirement, device records, and evidence that no company money reached me. Credit bureaus removed inquiries and guarantee references only after the lenders completed their reviews. One equipment lender initially insisted that the electronic signature bound me. Its own application log showed the document came from Mallory's device and the verification number belonged to Evan. The guarantee was withdrawn after counsel reviewed the file. Another supplier required a settlement allocating the genuine company debt away from me, rather than simply deleting it. The process took most of a year. During that time, fraud alerts remained on my credit, and every unfamiliar envelope made me stop before opening it. Being cleared eventually did not make the theft feel temporary while it was happening. The licensing board found that my inactive license and experience had been used without authorization. Pierce Civic lost its qualification status. The surety cancelled remaining coverage. The city recovered part of the North Valley overpayment through retained funds, insurance, asset recovery, and restitution proceedings. Workers received verified final wages from protected project funds where available. Legitimate suppliers filed documented claims. Another contractor completed the drainage work. Riverside was awarded later through a new compliance review. Evan and Mallory were eventually charged with offenses arising from identity misuse, false filings, procurement fraud, and falsified billing. They accepted negotiated pleas that included restitution, cooperation, and restrictions on future contracting. The final outcome came from months of records and legal process, not the hearing at City Hall. Their marriage did not survive the case intact. Mallory blamed Evan for insisting they could repair Crestline through one more project. Evan blamed her for the signatures and accounting entries. Neither explanation changed the documents showing they had acted together. My house and retirement accounts remained mine. Evan came to see me before his sentencing hearing. He looked older than 39. "If you testify that you knew about the company," he said, "they will reduce everything." "That would be false. You knew I was trying to build something. I did not know you built it inside my identity. I'm your son." He waited as though the relationship should finish the argument. I wanted it to. That was the part Evan still understood how to use. For one moment, I imagined saying that I had approved the company informally. allowing his attorney to turn 14 months of forged records into a family arrangement that had gone wrong. Then I remembered the suppliers who trusted my guarantee and the city employees who certified invoices carrying my signature. A false statement would not protect only Evan. It would transfer the cost of his choices back to everyone he had misled. "You are still asking to borrow my name," I said. I was trying to keep the Pierce legacy alive. A legacy is what people trust after you leave the room. You turned ours into something that needed an audit. I did not testify falsely. I gave the court an accurate history when requested, including Evan's cooperation after charges were filed and the damage his actions caused. Mercy did not require another lie. The following spring, I opened a small training program in the workshop behind my house. It taught basic construction skills, plan reading, estimating, and safety to young people entering apprenticeships. I named it the Donna Pierce Building Skills Workshop. I hung the original brass plaque near the entrance. Beneath it, I placed a new one. "Your name is not a shortcut. It is a promise." Evan used my name because he thought reputation was something a son could inherit. He learned too late that a good name is not passed down. It is earned every time you put it on the work. If your own son stole your identity because your name could open doors his no longer could, would you help him reduce his sentence after he confessed? Or did he stop being entitled to the family name the moment he used it to hide fraud?